Today we're looking at 7 things that you should stop putting in your will. And if you stick around until the end, we're going to talk about 3 things that you should consider putting in your will. Hello everyone, my name is Joseph Radzin IV, your trusted attorney with Radzin Law, PLLC, and I'm a licensed attorney here in the state of Michigan that regularly practices probate law and estate planning. We are looking today at 7 things that you should not put in your will. And this, again, will be specific to Michigan law. And if you're drafting your own will or you're sitting down with an attorney, these are some things that you should consider avoiding putting in your will. So number 1 is going to be funeral wishes. Putting funeral wishes in your will is, that's just not the document to do it. It's going to be likely that will is going to be read a week, 2 weeks, a month, 2 months after your funeral. A will is not a document typically people run to immediately when someone passes away. So if you're putting funeral wishes in that will, it's likely that, maybe your family they're going to bury you because you didn't have that conversation with them. They bury you, and then a month later they look at your will and read, oh, he wanted to be cremated. Well, now what is their option? Are they going to, dig you up and take you to a crematory? It's unlikely. So a will may not be the best document to use to express what your wishes are for your funeral. There may be a different document. Have conversations with your family, have conversations with your personal representative as to what your wishes are. Write them an email or send them a letter or something and express what you wish versus putting it in your will. Number 2 is going to be if you want to be an organ donor or donate your body for science or something to that effect. Again, a will, for the same reasons that we just talked about for the death, is not going to be a document that the family members are going to think to look at right away. So, and as far as organ donors go, or, donating your body to science, that's something that needs to be known before even you pass away so that arrangements can be made to make sure that your organs are properly preserved or your body is properly preserved for that intended purpose, donating organs or donating your body to science. So that's number 2. Let's look at number 3. Life support provisions should not be in your last will and testament. Your last will and testament is what it says, your last will and testament. So your life support provisions are going to be, you're going to want them in a different document, like a power of attorney for health care or a living will. That's something that a lot of people will say, but I think they can often confuse it with the last will and testament, which is the last will and testament of what you want carried out in your estate after you pass away. So again, not a document that you want someone to try to run to look for life provision, life provision terms as to how you want your doctors to treat you at the end of life, or if you're in a coma or anything to that effect. All right, so not a good document for life support provisions. All right, so we're on to the next number. We are on number 4. Let's talk about stocks for a second. Let's say that the will talks about the stocks going to Sarah. So Mr. Smith says, I give all my stocks to Sarah. All right. But years back when the stocks were set up, Mr. Smith was smart enough to put the ownership the ownership or beneficiary designation, whatever your stock allows for, it is to be owned by Mr. Smith's trust. All right. So the will says the stocks go to Sarah, but the trust is the actual owner or the recipient of the stocks. And within Mr. Smith's trust, it doesn't say that the stocks are to go to Sarah. Rather, his trust says the stocks are to go to my great-grandchildren, Joseph, Jude, and Jane. All right. So the designation there in the trust is going to govern. And that means that Sarah, as much as she would like to have the will govern. It's not going to, and she's not going to get Mr. Smith's stocks. The great-grandchildren, Joseph, Jude, and Jane, are going to be paid out under the terms of the trust, not under the terms of the will. And again, that is why a will is not the greatest place to list what happens with your stocks. So stocks are number 4. Number 5, assets held in an LLC. And we'll just start right with an example. I think it's easier to explain. So let's say that Mr. Smith owns 4 properties, and those properties are owned technically by an LLC, right? So they're titled in the name of the LLC. When Mr. Smith purchased the properties, he made sure that the seller wrote down the LLC on the deed as the owner. Okay, that's how they're titled in the LLC. So technically, the LLC holds on to and owns these properties. And Mr. Smith's will says that one property is to go to Bob and the other property is to go to Josie. All right. Well, that's not going to work. The will is not going to be able to pass those properties on to Bob and Josie, because technically the LLC is the owner. All right. And that LLC is going to survive Mr. Smith's death. So the LLC, because they're the rightful owner, and Mr. Smith is trying to pass on that ownership, the right way to do it would be Mr. Smith either bequeathing ownership interest in the shares of that LLC to Bob and Josie, right? Or, there'd be some other mode of transfer, either making them members currently while Mr. Smith is alive, transfer. There are a host of other ways in Michigan that you can do that. All right, we're not going to get into all of them here. We'll have a much longer video. Again, to summarize, the LLC, if they're the owner of the properties, and Mr. Smith lists, I want, XYZ property to go to Bob and ABC property to go to Josie, it's not going to happen. The will is not the right vessel or not the right document to transfer those properties. Mr. Smith will need to do it another way. So the 6th thing to leave out of a will here in Michigan would be the reasons why the testator, the person that's, writing the will, the reasons why that person is giving a gift to a specific individual, right? For example, I'm leaving my house to my daughter Jane because she came and visited me every month and my 2 deadbeat sons did not, right? That's the kind of stuff that we want to leave out. Same thing if it was any sort of gift. I'm leaving more money to my sister Sarah because she came over every Christmas and my children did not. That sort of thing, we don't want to give reasons in our will. The last thing, we're on number 7, if you're still keeping up with us here. The last thing would be naming life insurance, annuities, IRA, and beneficiaries that are in the listing specific people in your will that are to get those policies or the proceeds from the payouts on that IRA. Again, the reason being, you don't want the beneficiaries, when you set those policies up, the life insurance policies back in the 2000s or the 90s or the 80s, to be different than who's listed in your will. A beneficiary designation is going to trump whatever the will says. And really then you just have competing things. The will is not the right way to do that. So leave them out of the will. Leave out, I want my life insurance policy to go to Sally Smith, all right? Or your annuities, your IRA. Beneficiary designations are going to govern, not the will. If you need to open a probate estate and don't know where to start or which forms to use, I will send you a free probate tip sheet. All you need to do is go to radswinlaw.com. The link will be in the description box below, or you can search Radswin Law in any web browser. When you get to our homepage, you should find the Get in Touch section. It should be towards the bottom. Here you will enter your name, email address, and the words probate tips in the very bottom box. Then click submit. I will then send you an email so that you can download this free probate tip sheet. The tip sheet has links to many of the probate court forms that are required when opening or administering a probate estate. It also has some other checklist items that you will need when opening a probate estate. So head on over to radswinlaw.com to get yours today. So if you stuck around until the end of this video, now we're going to look at 3 things that someone here in Michigan should consider putting in your will. All right, number 1, clearly designating who you want as your personal representative. All right. And that may seem like, yeah, no kidding. Thanks for that bonus tip. All right. Now let me explain a little bit more. The one person that you want to serve as a personal representative, if you're only naming one, number 1, check with them, make sure that they're up for the task. You may want to have them watch some of our other videos, like how to open a probate estate or some of the duties that a personal representative has. All right. And let them make an informed decision, because some people are not up for the task. They may love you, they may be your best friend or your family member, whatever the case may be, but they just might not be up for the task. So ask them, and then even if they say yes, right, maybe by the time you pass away, their life circumstances have changed. So in your will, you want to name more than one person as a personal representative. You'd like to have what we call a backup. It's very easy. It's just a backup person that could serve as your personal representative if the first person you name is not willing or able to do it. The second thing about personal representatives and clearly identifying them. Now let's say, well, instead of naming a backup, I want 2 people because I can't decide between my 2 best friends. So you name 2 people as your personal representatives, or I have 2 siblings and I want both of them to serve. Okay, so in that situation, the thing that you should consider doing if you're going to have co-PRs is giving or authorizing the right for each of them to act independently from one another. All right, independently from one another means that they don't have to essentially collectively vote on whether they sell the house or they have a yard sale or whatever the case may be, or who's getting what does the will say. All right. So the authority to act independently essentially frees them from each other and allows them to make decisions unilaterally and keep the administration of the estate moving more fluidly. All right. And that way, it avoids, if you have an even number, the deadlock kind of voting situation. The next thing you should consider if you're drafting a will here in the state of Michigan and you have minor children, one of the appropriate places to put who you want as the guardian or the conservator for your child or minor child is in your will. All right. The guardianship and conservatorship positions can be ordered by the court, and they can use the will as a guiding document. All right, so that's something you should consider. And then also, again, making sure that the people that you want to list in that document are willing to take on the extreme burden and task, I should say, not necessarily a burden, but a task of raising children or making decisions for your children in the event that you pass away. All right, I didn't mean to say that children are a burden. That's not what I was hinting at there. All right, so what happens? Okay, this is the last thing. In your will in Michigan, you would want to make clear what happens to your residuary estate, whether you're going to have a person, a group of people receive the residuary estate, or if you're having what's called a pour over will drafted, if the residuary of that estate is supposed to be poured over into a trust document. All right, so those are some things that you want to make very clear in your will if that's what you're doing. If you have a will or you have a trust set up as well, making sure that the residuary is figured out what you're doing with that. If you have not subscribed to the channel yet, please do so. It helps us get informational videos like this out there. We love to see your guys' comments on videos like this, whether you've dealt with probate or you've had an issue with setting up an estate plan or anything like that. And also, please boop that like button, hit that like button, and help us out as well. Thanks for watching, everyone. We'll see you next time.